Welcome to the first Ask a Lawyer series webinars this year. And today's topic is going to be Estate Planning 101. And let me share my screen. Right. And feel free to let me know if you have problems seeing the screen. Let me turn off this one right here. So today's webinar is brought to you as a collaboration between the Sacramento County Public Law Library and HERA, which stands for Housing and Economic Rights Advocates. If you have any questions as we proceed, please feel free to type them in the Q&A box and we will address them at the end. Disclaimer, this presentation is for informational purposes only and does not create an attorney-client relationship between the participants and either the SAC Law Library or HERA. More information on additional resources available to you will be provided at the end of the presentation. HERA is a statewide nonprofit legal aid agency, and our mission is to ensure all people are protected from discrimination and economic abuses, especially in the realm of housing. HERA provides free legal advice and counseling for tenants, homeowners on all topics related to foreclosure, including difficulty faced in working with servicers, relief from loan modification scams, and post-foreclosure debt collection. Estate planning is essentially part of this whole project of keeping people housed for generations. Today, we will talk about the 5 W's: what, who, when, why, where of estate planning. First, let's get some true or false questions going to be a bit more interactive. The first is, I do not own anything, therefore I do not need estate planning. Is that true or false? Feel free to give your answer in the chat if the chat function works, or you can have an answer in your head. All right. This is false. You still have yourself, even if you do not own anything at the end of life. Estate planning is the process of handling personal and financial affairs during lifetime and after passing. So we will talk about both during and after. Second one, I have 3 children, Omar, Oscar, and Olivia. I can leave my house to just Oscar. Is that true? The answer is yes. We just have to make sure to put that in writing. All right, the third one. I have a written will. My child therefore does not need to go to probate court after I pass away. Is that true? This one's a little tricky. This one is false. Judge will have your assets go to your beneficiaries pursuant to the terms of your will. So probate is still needed if there is a written will without a trust. And we will discuss that in more detail. All right, my children get along so well, so I don't have to worry about anything. That's the last one. I think this is a no-brainer. It's not right. All right, so what is estate planning? It's a process that involves your people, your loved ones, and your property, your treasure. And it addresses your future needs, whether it being during lifetime, later on, if you become incapacitated, or afterlife, after your life. A will is part of the planning process, but you need other documents as well to fully address your estate planning needs. For a full estate planning packet, it typically includes durable power of attorney, and this is the first blue bubble, and the bottom blue bubble, a healthcare directive. And then in the middle is a trust. And there's also usually a will, a simple will that will go along with the trust. In some instances, trust is not necessary, but it's more rare. It's usually the case that trust is necessary. And the timeline matters. So after the date of death, the durable power of attorney and healthcare directive documents will no longer be relevant. Trust and the will, they are still living, but they become final. No additional changes could be made after death. Why would I need estate planning? Typically, it's for two main purposes: for incapacity planning during lifetime, and for post-death planning for inheritance. For incapacity planning, you're using power of attorney and healthcare directive documents to designate someone that you trust to manage your assets and also to make healthcare and personal care decisions for you if you are not able to do so later for yourself. And for post-death planning, you get to utilize the documents to stay in charge of your future affairs, even beyond your life here. And also the details of who gets your assets at what time, what age of their life, if you will, and who manages your estates, making sure things get carried out according to your wishes. So we talked about the what and why. Okay, so we will talk about the inheritance planning, the post-death planning documents first. And at the end of the webinar, we'll talk about the incapacity planning documents. So we're separating them into the two categories. This became really big for some reason, right? Okay, so after we are gone, a very important legal procedure is relevant, and that's called probate. According to the probate code, California law, there is a threshold above which your estate will be subject to probate. There are exceptions to that, but in general, if the gross value of the decedent's real and personal property in California combined exceed $184,500, then probate is your estate will be subject to probate. If no exceptions apply. And how do we determine the value? It's the date of death value that matters. So we will explain further. I mentioned exceptions. There are assets not subject to probate. Their probate basically is the court procedure to determine your estates and what they are and who gets what and who gets to manage that. And the exceptions are assets here in these yellow circles. So the first one will be property held in the decedent's revocable trust, and we'll talk a lot more about that. The second one is real property, so houses, apartment complex, land, and think about these type of properties held in transfer on death deed. We'll mention that later as well, what that is. And the third one here, multiple party account, POD, which is pay on death account, and total trust account. They mean the same thing. Basically, multiple people on a checking or savings account, or other types of account, and the person whoever passes away, the remaining people on the account will own the property equally. And so the such accounts, since they as long as somebody's still alive, just because other parties have passed doesn't trigger probate. But if the last person also passes away, then probate is relevant. And then the fourth circle on top here is if the estate is less than $184,500. And yeah, and it's rare because it's hard to have everything added together at the end of life to be below that number, and we're talking gross value. So even if there's a outstanding mortgage on the house, it's fair market value at date of death that's taken into account. Okay, and then the second the level here, first circle down on the left, property held by the decedent in joint tenant. You might see joint tenancy or husband and wife owning something as joint tenants with right of survivorship. You might have seen that language on the grant deed when you purchase the house. And that has nothing to do with tenants in the sense of renting an apartment. But joint tenant is this concept where, similar to that multiple party account that we talked about. Sorry, I have to correct myself a little bit. When I was talking about the pay on death account earlier, I'm talking about, so there are different things. There's multiple people on the account, and there's also pay on death, meaning you're designating a beneficiary where you're telling the bank to pay the beneficiary named upon your death. And if you designated pay on death beneficiary, that account will be not subject to probate. So that's a way to do estate planning. Okay, back to joint tenants down below here. This is where two people or more people on a piece of property, could be a house, and it could be other type of property. If you own it as joint tenants, the last person that is on the property will own 100%. So whenever somebody passes away, the remaining people own it equally. So as long as somebody is alive, there is no probate, no probate scare. And then this bubble in the middle, down below, property passing to surviving spouse or registered domestic partner. Similar idea. It's basically the same setup as joint tenants. Multiple people on the property. The last person gets all. Until the last person passes, there is no probate. And then the last bubble here, retirement or death benefit property with beneficiary designated. So 401k, 403b, IRA, and other benefits that could or life insurance where you can designate a beneficiary, and you should, and that's the property would be excluded from the probate proceeding. All right, so we will talk about that first bubble, property held in the decedent's revocable trust. So when you read a revocable trust document, you might encounter these basic terms and provisions. I'm throwing them out here so that you can be familiar with them, and if in the future you encounter them, you don't have to be overwhelmed. So there are terms like settlor, grantor, trustor. They're the same thing. They're the person setting up the trust. And there are terms like trustee and beneficiary. And you see terms like revocable, inter vivos trust, living trust, inter vivos and living, same thing. And you see pour over will, and that's a simplified will that goes with the trust to make sure everything is accounted for, everything you own is accounted for, how you want to designate them after death. And so interestingly, when you set up a trust, you are multiple things. You are your own trustor, you are the trustee, and you are also the beneficiary. As long as you are alive and well, you are all three positions, because when you do a revocable trust, your property, you're still enjoying the property the same way you enjoyed it all this time. You're still able to buy and sell and loan and live in the house and do whatever you would like to do with it. And then when you designate the people, you will designate successor trustee. So on this right side here, who can take over as the trustee, acting trustee, after you're no longer around or after you lose capacity. And that person would be making sure to really execute your wishes according to the terms of the trust. And then you designate beneficiaries for after you're no longer around. They could be your children, other good friends, or charity that you really like, and all kinds of beneficiaries you can designate. But during lifetime, you are your own beneficiaries. That's how you can ensure you still enjoy the properties the same way. And there are provisions about trustee compensation and accounting obligations for trustee. And there's some provisions that protect yourself. The spendthrift clause that would make sure to state it very clearly that your beneficiaries, creditors meaning many things, people that loan the money, or it could be your beneficiaries, ex-spouse or anybody that might have a claim on their properties. They don't get to have a claim on your properties as long as you're still alive and beneficiaries are not inheriting yet. So there's clause to protect yourself. There's also a clause to kind of keep the family peace, no context clause. So kind of these incentivize your beneficiaries from fighting over inheritance, and whoever initiates a challenge will lose that person's share according to the trust. So there are these contents in the trust. And why do we need that? This is a chart that compares living trust with a situation where there is no trust. So that could be no will at all, or there is a will without a trust, and where probate is basically the probate is needed. And so you compare on the living trust side of things, there is no probate. You don't have to have your beneficiaries go through the court procedure after you're gone, because everything is already stated clearly in writing, notarized, and in your documents. And it's also a private record that doesn't get recorded or published anywhere. Versus on the right side, if probate is needed, then your beneficiaries will have to go through the court procedure, which is hassle. And also it's a public record. The final will and testament gets published. That's how you see these news articles after some celebrities pass away, the details of their will. And then another benefit of the living trust on the left side is there is no statutorily guaranteed fees to successor trustee or his attorney. Whereas on the will and probate side of things, there is statutory compensation set forth in the probate code, and that's a higher amount of money. So in the living trust, you can say, I give my successor trustee a reasonable compensation at that, and even that is not guaranteed to the successor trustee. But the statutory compensation, it starts at 4% of the first $1 million, and it gets like different percentage above that. It's complicated and it's just more costly. And then another advantage of living trust is that the successor trustee can do all the tasks without court supervision or approval. Whereas in probate court, executor or appointed personal representative, they have to do everything under court approval and timeline. And another benefit of living trust is that assets in the trust is not subject to estate recovery. And this is relevant if you receive or see a possibility of receiving Medi-Cal in the future. And this is a law change that's happened in January of 2017, where on the other side, if probate is needed, the properties that are subject to probate are also subject to estate recovery. So that's a major one. At the end of the day, on the living trust side, there is just more money and shorter time to your beneficiaries, whereas on probate side, there's less money and longer time. And sometimes your estate end up with really distant relatives or even strangers in some extreme cases. So we talked about will. What is the will? Will, similarly to trust, it contains your wishes and desires. It talks about who gets your assets after your death, and also the details of who manage your estate. But the thing about will by itself is that probate is still needed, because the court is interested in seeing whether the will was validly executed. There are certain elements about the will. If you don't meet it, you end up with an invalid will. So court needs to determine the validity, and the court will also make sure if it's valid, then distribution happens according to your will. So probate court is very much involved when there is only a will in place. So probate, excuse me. By now you probably sensed that you don't want probate, but what is it? Probate is a court supervised process for transferring a deceased person's estate to the beneficiary named in the will. And it's also a process to validate decedent's will. And in the same process, the court appoints a personal representative or executor or some other similar names or fancy names with a similar meaning. And if there is no will, then probate would make distributions according to the probate code. So probate is a good idea initially because it's trying to protect the rights of the dead. But in practice, it just becomes costly, and it's lengthy, and it's something that we can totally avoid by making our desires clear in the trust. So what happens if there's not even the will? How are distributions made pursuant to probate code? So this might be a little small. This is the probate code section where it talks about a person. So if there is no will, we don't know who the executors should be, and the court will look at this person's relationships, and according to blood closeness, to determine the sequence of who should be the first in line to be appointed as the administrator or the personal representative or executor. All those things, same meaning. So you can tell that this is like a cookie cutter solution where the spouse is the first in line, and then children, grandchildren, other issue, meaning other descendants. If nobody's alive or around or available or willing, then it's parents, and then siblings and children of siblings, and then grandparents and sibling of grandparents. So it's already getting a little distant at this point. So again, this is a one-size-fits-all solution to determine who should be the executor when there is no will that specify that. Yeah, so if, say, somebody's still married, but really not close relationally anymore to the spouse, that person probably doesn't want the spouse to be the first in line. Or children, everybody has a different family, and yeah, you can tell this is not ideal. And in extreme cases, when we go all the way to the bottom, the executors could be even public administrator, totally strangers, or creditors, or any other person. So that's a chilling thing that's like written here. This is a chart that's kind of illustrating the same thing. The degrees of relationship in the probate code is a one-size-fits-all. And not only they use this to determine who to appoint as executor, they also look at this kind of a sequence to determine beneficiary. And it's not ideal since everybody has a different family situation, dynamics very different. So we want to at least have a will to make it very clear what our wishes are. And this is a probate timeline on the Alameda Court website that we screenshot from, and it doesn't show things very clearly, but the idea is to show how time consuming and confusing probate process could be. There are all these deadlines and steps that need to be taken. And especially if somebody loses a loved one, that person is still grieving and needing to comply to all these timeline and details. It's just a lot. So again, that's also why we want to avoid the probate process as much as possible. And we totally can do that right now when we are alive and well. So I mentioned statutory fees a little earlier, where in the probate scenario, there is statutorily guaranteed fees to court-appointed executors and also probate attorneys. And it's a lot. It's about 4% of the 4% of the first million, and then it's different percentage after that. And this is like a chart to illustrate how quickly it gets like it just becomes bigger according to how big your estate size is. So here's an example to also compare when somebody has a trust during lifetime and with somebody who didn't have a trust. So when probate is needed, let's just imagine for both of them, they passed away with a fair market value, gross fair market value, 1 million estate. And let's say that's just the house. All they had is the house, and that's worth 1 million. And there's an outstanding mortgage of 300,000. Then the house on both sides will be 700,000. And let's imagine the cost of administration is 20,000. So cost of administration is basically a house, when you sell the house, there are costs associated to it. You put it on Redfin or some other listing website, and you hire agent, you stage the house, all these things. The cost in total, imagine that to be 20,000. You end up with a 680,000 balance. That's money in your pocket. On the probate side of things, you have a statutory fee of about 23,000 owed to the personal representative. On top of that, another $23,000 statutorily guaranteed fee to the probate attorney that you use in the probate case. So that's just the basic statutory fee. There could be other fees, and we don't know how much that will be. But even if not at all, additional fees, your distribution balance, in the probate court will start at 634,000. Whereas if there is no probate needed, there is no guaranteed statutorily guaranteed fees, then you can start with the money in your pocket, the 680,000. So it's a big difference here. Here's another way to bring this home, and also a little quiz. Let's see. Dear Judge Judy, does Pamela's estate need probate proceeding? So Pamela passed away on March 31st, 2018. She left behind these assets, a house that's valued 300,000. It's a very low value in California. And this house is titled as Pamela, trustee of the Pamela Trust. And the trust is dated Christmas of 2007. And Pamela also had left behind 2 IRA accounts, and Ben is the named beneficiary. The third thing is the life insurance policy, naming her elderly mom, Stella, as the first beneficiary, and Leo as the second beneficiary. And Stella died 2 years before Pamela. And then lastly, checking and savings account, naming boyfriend Tommy as the beneficiary. Do you think there is probate proceeding needed for Pamela's estate? Yeah, Pamela doesn't need probate. She's done all her homework and all the necessary steps to really make sure she uses all the probate exceptions to her advantage. Very good. Okay, next, let's see. Same, very similar estate makeup for Alex, who died on the same day, house of the same value, titled in Alex, an unmarried man. IRA accounts with no beneficiary designated. Life insurance designated Sean, his father, as the beneficiary and no other beneficiary. Sean passed away 2 years before Alex. And checking and savings account naming girlfriend as beneficiary. And about 20 people claim to be his girlfriend. Does Alex's estate need probate proceeding? It's probably pretty obvious. He does need probate proceeding because there is no exception to probate that's at work here to his advantage. And all these things listed are subject to probate. Too bad that he named a beneficiary for his life insurance. He did that, but because this person passed away before him, it didn't work. He is still subject to probate. So always good idea to have some contingency plans, alternative appointed people for your positions including successor trustees, your power of attorney, and your power of attorney for healthcare, and also your beneficiaries. All right, we mentioned briefly property, real property held in transfer on death deed. This was the second big circle in those exceptions. And sometimes people think it's a kind of a quicker way or like a faster and cheaper way to do estate planning, especially if the main thing that people are trying to do estate planning on is the house that they live in. I would argue that it's not quite a replacement of the traditional estate planning, through a living trust. And there are several reasons to that. So let's start with the basics. So transfer on death deed is written in the probate code in California. And I believe probably about half of the states in the country have transfer on death deed. And some states don't. There's some eligibility requirements. So real property improved, meaning not just a barren land, but houses on top of that or other agricultural things, and it's improved with not less than one or more than four residential dwelling units. So not a gigantic apartment complex with tons of residential units, and also not less than one. So at least like single family houses fits squarely in this category. And then condo is eligible. And then for agricultural land, there's these restrictions to who can be eligible. And there's also formalities requirements. This is where the headache comes in. I mean, first of them is not counterintuitive. Beneficiary must be identified by name. So this is a deed that looks very similar to the typical grant deed, but there are differences, and the major difference is there is a place where you put down beneficiaries who essentially receive the property, who gets to be on title of the property after you pass away. But the headache is you have to sign and date and sign in the presence of a notary and have the deed recorded within 60 days after you signed in the notary public's presence. So that's a hard deadline. And not only that, if you change your mind later on, say, oh, I just want to just scrap this whole thing and do the traditional living trust instead, and if you want to, just get rid of it, you have to do the same formality for revocation. So when you revoke it, you do a revocation document. You also have to record it within 60 days, or else it's not valid. So as you can see, anytime when these short, hard deadlines are in play, things tend to get messy if not done right. So that's why I'm not a big fan of transfer on that deed, but I will say they come in handy in some special circumstances. For example, if somebody is on their deathbed and or terminal stage of terminal disease, you need something fast in dealing with estate planning on the house. Transfer on that deed is a faster way and many times cheaper way than living trust. And if you especially know very clearly who the beneficiaries are, and like who you want the beneficiaries to be, and you're okay with them inheriting it equally, you can use a transfer on that deed for that situation. But again, overall, living trust has a lot more room for customization, and also it's a much more established estate planning instrument. So it in practice is less messy. So that's that for transfer on that deed. This is a simple 2-pager that kind of show you what it looks like. And on the bottom of the first page on the left, it has a beneficiary designation, and that's the part that's special to TODD. All right, so that was a lot of talking about when you are gone, what documents you can use for inheritance planning. So mainly trust and will. Now we're gonna briefly talk about when you're still alive. Why do we worry about estate planning if say I don't have a house? Excuse me. So I mentioned these two blue bubbles: power of attorney for financial purposes and healthcare directive for healthcare purposes. And these documents are relevant only during your lifetime. So power of attorney and healthcare directive are important part of your estate planning. It allows you to plan for incapacity. You name someone or several people with some contingencies, people that you trust, to help you make necessary financial, personal, and healthcare decisions. Just in case later on you do become incapacitated and not able to care for yourself. It also allows you to describe your desires about future care, preferences for using artificial nutrition, power to make annual gifts for estate tax reasons, preferences for in-home care over facility. All these things you can put down in writing in these documents. And the main purpose of having these documents set up is to avoid expenses and potential conflict of a conservatorship proceeding in the event of incapacity. For durable power of attorney for financial purposes, there are different parties in the document. So mainly the principal and the agent. So you will be the principal when you set up the document, and you name someone as the agent, and that person is called attorney in fact in the document. And there's also springing versus imminent. So springing is usually we have the springing powers where you give your agent powers when you sign the document in the presence of the notary, but they don't have the powers immediately. Instead, they have the powers. They can actually act on the powers that you grant them when you become incapacitated, and the incapacity can be determined by doctors by issuing a document. So that's the idea of springing powers. And you can also customize how much authority you grant. You can give them a blanket authority for everything in your financial decision realm, access to your bank accounts, everything. Or you can limit the authority granted. But even if you give them everything, like you're not relinquishing all control. The agents have to act to your best interest, and they have that duty by law. And for durable power of attorney and healthcare directive, when you set up these documents, you will have to name a primary agent and a secondary agent. You can name more. And also you want to think about having someone who's assertive, adult, and someone who's close by, especially for healthcare directive. Sometimes people want to name their kids as co-agents. We typically don't recommend that. it just gets kind of complicated when everyone has to sign on everything all the time. And once you set up these documents, it's a good idea to periodically review them to see if you want to make changes. And especially, upon the life-changing event, marriage, divorce, children, um, adding children, I don't know, all kinds of major life changes could prompt you to change the documents. And it's also a good thing to keep the conversation going in the family about your desires about the future. So I briefly mentioned conservatorship, which is another court proceeding that we're trying to avoid here through setting up the POA documents. So if you don't have those documents in place, and say if you lose capacity due to a disease or a bad injury or some complications, then if you're not able to handle the basic daily needs of yourself and not able to handle finances, then the court needs to appoint someone, a conservator, to help you manage these affairs. And court also supervises each action and the decision of a conservator. And if needed, even put conservatee with dementia in a locked facility. And so these are big decisions that you don't want to relinquish control over to the court to determine. And also, whenever there's a court proceeding, there's usually more time and more money. So there are other documents or other tools that you could utilize in the healthcare realm for specific reasons, and they're not the same as Advance Healthcare Directive, but they could work with them. They each address little different situation, but they work together to really help someone who is not able to assert their wishes in the moment. So there's a post form, and there's the DNR form, and there's in California, there's a end of life option act, and there are some specifics to that those are all not the same and does not replace Advanced Healthcare Directive, but they work together with the Advanced Healthcare Directive to ensure your care even if you cannot speak up. This is an example of the post form to alarm first responders about this person's wishes. And this is the DNR form example. So far we've talked about the typical documents in a estate planning packet, and also the timeline for them and different purpose of them and the different considerations that we should have. If you are interested in setting up your estate plan, you will want to meet an estate planning attorney. And if you're married, to meet the attorney with your spouse. And you provide personal and financial information to the attorney. Usually, attorney will give you a questionnaire to collect the information. And you continue to review the draft until you're satisfied. And then you formally execute your estate planning documents in the presence of the notary. Then your estate planning documents are legally valid, but that's not the end of the process. A very important next step is to actually fund the trust. So without funding, your trust is empty, and it does not provide the protection of probate avoidance. So how does funding work specifically is something that the attorney will help you with. And after you set it up and funded a trust, you want to review the estate planning periodically If a new grandchild is born, you want to name that grandchild by name as the beneficiary, then you can have the attorney help you prepare an amendment to address that. That's just one example. There are many other things that could happen that would prompt a change to the estate planning documents. So update accordingly. Well, these are celebrities that unfortunately didn't update their documents before passing, and as a result suffered long court proceedings, a lot of fighting over the estate, and time wasted, family split, all kinds of things. And yeah, I think maybe if I remember correctly, Barry White had a long-term partner who didn't get to take after his estate because he never formally divorced his wife, who was distant, and the wife took it all. Something like that we can avoid by setting up and updating our estate planning documents in a timely manner. So if you have any questions, you can give us a call at HERA here, and also send us an email. We have a lot of resources on our website here too. If you are interested in setting up your estate plan, our admin assistants can schedule you to talk to one of us at on the estate planning team here at HERA to help you further. So that's the end of my presentation. I'm gonna look at the Q&A box here and see if I need to answer some questions. And if you have questions, you can feel free to also type that into the Q&A box. The first question is, can someone have two beneficiaries of a totem trust? So totem trust is, I believe, a kind of a arcane term for pay on death accounts. I think you can have more than one beneficiary for those accounts. So it's a good idea to talk to the financial institution that you bank with to get the specifics on their requirements and limitations. Second question, can a spendthrift trust control the amounts the beneficiary can spend? The spendthrift clause that I was mentioning is just to illustrate, just to put in writing clearly that the beneficiary's creditor don't get to have a claim on the trustor's estate when trustor is still living. So trust doesn't shield you from your own creditors, but it could shield you from your beneficiaries' creditors as long as distribution has not happened yet. The properties are not there yet. So theirs yet. So I'm not sure if there is something called a spendthrift trust, and I've never heard of any spendthrift trust controlling the amounts beneficiaries get to spend. If you want to have that restriction on how much beneficiaries can spend, you probably want to do that by saying, I'm gonna give my beneficiary this much money if when the beneficiary turns 25, and then another sum when they turn 35. Or you can be like setting up milestones. I'll give this much when the beneficiary graduates from college, and another sum when the beneficiary is married. So you can do those personalization on how you want the distributions to happen. And let's see. Any other questions? Where does the trust need to be filed at? can we name a child as the trustee when I pass away? So first question, well, where does the trust need to be filed at? So interesting question. Because a major benefit of the trust of the living trust is that you do not have to make it public. So when you say file at, I'm imagining your idea being recorded somewhere. You don't have to do that. And you want to just keep it as at a safe place at your house once you have that set up. And you want to also communicate to your trustee, your successor trustee, about where you kept it. And a lot of the times these days, people have a soft copy, the scanned version of it as well, saved up in the computer or somewhere. A scanned copy is just as good as the original. The scanned copy of the signed version, of notarized and signed version, is valid. So you might even just give your successor trustee the name of the drafter that prepared the documents for you. That person probably also has a copy. So you can do that. And second question, can we name a child as the trustee when I pass away? So trustees have to be adults. You can, a lot of people name their adult children as trustees. And if your child is, say, turning 18 in 4 years, or about to be 14, or something like that, where within a few years they will be adults, you can name them ideally as a secondary trustee, not the first successor trustee. You name them somewhere, and you can put a condition like so and so can act as my trustee as long as he turns the age of majority, he turns 18 or he turns 21. You can have that condition there. So yes. Yeah, let's see. Next question. Would the transfer on that deed be affected by a reverse mortgage on the property? Transfer on that deed. That's an interesting question. I have to think about that one. Well, kind of this is outside of the scope of today's conversation about estate planning 101. But in general, when there is reverse mortgage on the house, it's questionable whether this house could be saved for the beneficiary. If yeah, so I'm not sure. I'm not sure. That's the short answer. All right, I think that's the end of the questions that I see in the Q&A. And if there is no more questions, I'm gonna stop share real quick. I think we are done, exactly 1 hour. Thank you again for all of you that joined us. And we'll see you at the next Ask a Lawyer series webinar. Thank you and have a good weekend, everyone.